Hello, this is Professor James Strickler, and this is a course in American government. This lesson is from Unit 7 about the judicial branch. It's Lesson 6 about the idea of jurisdiction. In this lesson, you'll learn about the concept of jurisdiction, about geographic jurisdiction, subject matter jurisdiction, about federal questions, about original jurisdiction, and appellate jurisdiction. In previous lessons, we've been going over the principles that the American court systems have inherited from England. We call this our English judicial heritage. In previous lessons, we learned about the common law, about trial by jury, about our adversarial system, and about the idea of justiciability. In this lesson, we'll learn about limited jurisdiction. To understand that concept of limited jurisdiction, we must first understand what jurisdiction means. Jurisdiction is the authority of a court to hear a case. Now, don't confuse this with the concept we learned about in the previous lesson, justiciability. Justiciability was whether or not a case could potentially be heard. So, in order for a case to potentially be heard, there had to be a real controversy. The people bringing the case had to be the ones that were actually involved in the controversy. In other words, they had standing. And the case couldn't be against the government because the government has sovereign immunity. So if those things were in place, then a case could potentially come before a court. Or in other words, it was justiciable. Now we're going to talk about whether that case which can come to court can come before a particular court. In other words, does that court in question have the authority to hear that case? That is what jurisdiction is. Now, this idea that jurisdiction is limited, that only certain kinds of cases can be heard, is not something that other countries maybe necessarily agree with. There are courts in some countries in the world that claim what is called universal jurisdiction. The idea that they can hear any case from anywhere on the planet in order to bring justice. An example of this are the courts in Spain, where in the past they have claimed universal jurisdiction. And, for example, a case was brought in a Spanish court against a man named Henry Kissinger. Henry Kissinger was the Secretary of State for the United States of America during the presidency of Richard Nixon. Henry Kissinger was charged in a Spanish court for things that he had supposedly done wrong in Latin America. Now think about that for a moment. Henry Kissinger was in America. The things he supposedly did wrong were in countries in South America. Yet somehow somebody's bringing a case against him in Spain. The reason is because I said Spanish courts claim universal jurisdiction. They can hear any case from anywhere on the planet if they consider it to be a severe enough thing, like a crime against humanity, as they put it. So they say, well, we're part of humanity, we can hear the case. American courts do not buy into this idea of universal jurisdiction. Instead, jurisdiction in American courts is limited in some very specific ways that we're going to talk about. It doesn't apply to any case anywhere on the planet. There's three specific ways that jurisdiction is limited in our American court system. Those are geographic, subject matter, and the level of court. We're going to talk about each of these separately. So let's begin with geographic jurisdiction. This is easiest to explain by using a map. This map shows the courts that are called circuit courts in our national court system. It lays out the areas covered by these circuit courts. Now, I'll explain more about these circuit courts in a later lesson. For right now, just notice that each of them has a certain area that it covers. So, over on the left side of this picture, you see a big number 9. This is for the Ninth Circuit Court of Appeals, which sits in San Francisco in California. It covers cases from Washington, Oregon, Montana, Idaho, Nevada, California, Arizona, Alaska, Hawaii, and some United States territories out in the Pacific Ocean, Guam, and the Northern Mariana Islands. The notion is that of geographic jurisdiction is that the Ninth Circuit Court of Appeals can only hear cases from those areas. So if you have a case, say, in Illinois, you can't go to the Ninth Circuit to have your case heard. You will have to stay in the Seventh Circuit, which covers the state of Illinois. Now, this is a very broad example covering the whole country, but this principle is applied on smaller scales too. For example, if you're in the state of Georgia and you get a speeding ticket, you can't go to court in Florida to have your case taken care of. Matter of fact, within a state, if you violate a city ordinance where your particular city says you're going to get a ticket for letting your dog poop on the sidewalk or something like that, you get a ticket. You can't then take your case for letting your dog defecate on the sidewalk to a court in a different city. Each of these courts has a certain geographic area that it covers. And generally speaking, whatever controversy or law that you're going to court about has to have happened within the area covered by that court. The next limitation on jurisdiction we want to talk about is subject matter. As a general principle, what we're talking about here is the idea that if a court, for example, covers tax cases, then you can't bring a case in that court about a criminal matter. Or if a court covers military issues, then you can't bring a tax case into that court. Each court has its own subject matter that it covers. Now, with this concept of subject matter in place, then, I want to discuss a particular kind of subject matter limitation that the national government has. According to the United States Constitution, the national government can, the national court system can only deal with what we call federal questions. Well, what does that mean, federal questions? Well, the Constitution actually lays out 3 different kinds of federal questions that you can go to the national court system with. The first of these are questions arising under the Constitution of the United States of America. In other words, whatever's happening to you, you claim violates the Constitution of the United States. Well, if that's the situation, then yes, you can go to one of the courts in our national court system to claim that the Constitution was violated in your situation. The next kind of federal question concerns laws of the United States of America. So you can go to the federal courts if you say a law of the United States of America was violated in my situation, or that a law applies to me. For example, if Congress passes a law saying that you can sue somebody if something happens, then you say, hey, there's a law from Congress saying I can do this. So you go to court saying this involves a law of the United States of America. Then you can go to our national court system. The third way to get into the national court system is if you claim what happened to you concerned a treaty of the United States of America. Treaty is an agreement with some other country about how things should be done, and perhaps your situation is covered by that treaty, or what was done to you violates that treaty. These are the 3 types of federal questions that then allow a person to bring a case in the national courts. These are the subject matters that the national court system is assigned to cover by the Constitution. The third kind of jurisdiction to talk about is being in the right level of court. Now, notice as I've been talking about jurisdiction, the way to think about it is if you had a case. So first of all, geographically, your case, you've got to be in the right court that covers the geographic area where your case came up. You've got to go into the court that covers the subject matter of your case. Now you're going to have to go into the correct level of court. Now, what is meant by level of court? We're talking about the difference between what are called courts of original jurisdiction and courts of appellate jurisdiction. Well, what's the difference between the two? I'm going to explain them separately. Courts of original jurisdiction have 2 defining features. The first is they are trial courts. That's why they're called original jurisdiction courts. They are where a case originates. This is where you go in and you say, this bad thing happened to me, and a jury sits and they decide whether somebody's guilty or innocent, that sort of thing. It's where the trial happens. That is a court of original jurisdiction if they're having a trial. And what do they do in the trial? They answer questions of fact. The jury tries to figure out what actually happened and whether or not it violated a particular law. So, an original jurisdiction court is asking questions like, did this gun cause the death of this person over here? Like, for example, in a murder case. And are these the fingerprints of the defendant that were on the gun? Okay, these are the kind of questions that a jury in an original jurisdiction court would go through to try to figure out what happened. They're questions about fact. Now let's compare that to a court of appellate jurisdiction. You've probably heard of the idea of appealing a case. So you were in a court of original jurisdiction, you got a decision, the jury decided that the facts were such and such, and they, based on that, believed you had broken the law and you're convicted. You then appeal your case up to another court that has appellate jurisdiction. Well, what does that mean? There are two basic features of appellate jurisdiction. The first is that it is an appellate court, not a trial court. So you're not going there to have a new trial. You're not going there to call witnesses and present evidence. You're not there to try to dispute the facts. As a matter of fact, the appellate court will assume that the facts that were found by the trial court are the facts. If the trial court says, yes, that gun is what killed this person, the appellate court says, yep, that's the gun that killed the person. If the trial court says, yes, those are your fingerprints on the gun, the appellate court assumes, yep, those were your fingerprints on the gun. So now wait a minute, if you aren't there to dispute the facts of the case, if the appellate court's going to assume that whatever the facts were, as determined by the trial court, are actually the facts, then what are you there to appeal? In an appellate court, you are there because of questions of law, not questions of fact. Well, what do I mean by questions of law? Essentially, you're arguing to the appellate court that somehow the trial court got the law wrong. Yes, maybe they were correct. We can assume that they're correct, that that gun killed that person. Maybe we can assume that they were correct, that those were your fingerprints on the gun. But somehow along the way, they incorrectly understood or applied the law to your situation. And that is then what you are appealing. So how does this work? Well, an appellate court is going to be asking questions like, was the gun found through an unconstitutional search? And if so, then it should have never been presented in evidence, which means the jury should have never had an opportunity to even figure out whether it was the gun that killed the person. The jury should never have been able to have the opportunity to figure out whether your prints were on the gun. So they're not saying that the jury got those things wrong. They'd be saying the jury should never have been asking those questions in the first place because they should have never seen the gun because the gun was found unconstitutionally. These are the kind of questions that would be asked by an appellate court. Was the law correctly applied? Were the rules correctly followed in that lower court case, in that trial court case? Okay, let's review what we learned in this lesson. What does it mean if a court has jurisdiction? Does it mean that it has a jury? Does it mean that it can't render a decision? Does it mean that the judge decides the case? Or does it mean that it can hear a particular case? If a court has jurisdiction, it can hear a particular case. Which of the following is not a federal question? A violation of the Constitution, a violation of national law, a violation of state law, a violation of a treaty. A violation of state law is not a federal question. You cannot go to the national court system to dispute the application of a state law in your situation. You would have to instead claim that that state law violated the Constitution or a law of the United States of America or a treaty of the United States of America. Those are the kind of questions that a federal court can consider. What does original jurisdiction deal with? Does it deal with questions of justice, questions of propriety, questions of fact, or questions of law? Original jurisdiction addressed questions of fact. Were you the person who actually caused the murder, for example? What does appellate jurisdiction deal with? Does it deal with questions of justice, questions of propriety, questions of fact, or questions of law? Appellate jurisdiction deals with questions of law. Was the law correctly applied in your case? That completes this lesson. The next lesson will also be from Unit 7. It'll be Lesson 7 about judicial structure.